What was the reason for Title VII? Where did it come from? Well, of course, know that Title VII arose out of the civil rights movement of the 1960s. There's no doubt about that. Nevertheless, Title VII really has its roots in the 14th Amendment. Now, the 14th Amendment was an amendment that was passed after the Civil War, and the 14th Amendment fundamentally changed the nature of the United States. When you're looking at United States history, you can look at really two United States. The first, from the time of the Constitution in 1787 through 1866, the end of the Civil War, and the passage of the 14th Amendment. The 14th Amendment changed the Constitution. The 14th Amendment, for the first time, provided for equal protection under the law. And what that meant was people are going to be treated the same by the law because they are now guaranteed the equal protection of the laws. We know that did not exist before the 14th Amendment. So therefore, the 14th Amendment changed that notion. You know, when we talk about things like the Declaration of Independence, all men are created equal, those words were not echoed in the Constitution. The Constitution says nothing about that. The Constitution, in fact, is based on the idea that not everyone is equal. Nevertheless, that's what the 14th Amendment was about bringing those ideals of the Declaration of Independence into the Constitution. Now, the 14th Amendment did several things, and you should probably know what these are because they're still relevant today. We hear about these things today. And starting with this notion, the amendment included a broad definition of citizenship. As you probably know, are aware, the United States has what's called birthright citizenship, meaning if you are born in the United States, you are a citizen of the United States. That's not the law everywhere. And matter of fact, it's pretty rare. It's relatively rare. If you're born in Italy, doesn't mean you become an Italian citizen. Birthright citizenship, however, was not applicable to the United States before the 14th Amendment. So where did it come from? Well, critics of the 14th Amendment would say that birthright citizenship was simply a solution to fix the problem of what do we consider former slaves. Remember the worst decision in Supreme Court history, the Dred Scott decision. Dred Scott said that people of African heritage could never be United States citizens. So we needed a constitutional amendment to do away with that interpretation of the law. And so they settled on this, birthright citizenship. If you were born here, you're a citizen here. Now again, critics would claim that this was just about how do we treat former slaves, and that once that group was made citizens, then we should drop the notion of birthright citizenship. Just last year or so, President Trump argued that he could sign an executive order ending birthright citizenship. But what people fail to understand is that birthright citizenship was on purpose, because what the drafters of the 14th Amendment wanted to do was they wanted to prevent a underclass of people from ever developing again. They recognized the problem with slavery was the development of this permanent underclass of people. And therefore, the only way to address that was to not only make these individuals citizens, but to ensure that we would never again have that underclass of individuals. It's based on the idea that two children born in the same hospital on the same day should have equal opportunities in life. And we start with that most fundamental guarantee of citizenship. The second thing that the 14th Amendment did was it guaranteed citizens the equal protection of the laws. What it meant is that for the first time in the United States, people were equal in front of the law. The law was required to treat people, similarly situated individuals, the same. So the amendment guaranteed the equal protection of the law. And finally, the amendment, for the first time, applied the Bill of Rights to the states. Remember, the Bill of Rights are all aimed at Congress. Congress shall make no law, with the idea that the states would be protectors of people's liberties. But in fact, just the opposite proved true, that we learned that the states were the leading infringers on people's liberties. And so all of those protections that were found in the Bill of Rights as applied to Congress were made to apply to the states as well. So the states who at one time could have prevented your freedom of speech or prevented your freedom of religion or established a religion or put in place for rules for warrantless searches and seizures, all of those protections were now applied to the states as well. So these three things fundamentally changed the nature of the United States. Now, this was all an attempt really to restructure the United States. After the Civil War, Congress recognized that something had gone terribly wrong, and therefore they were intent on creating a new United States. They did so through a series of legislation, starting with the 13th Amendment. Now, the 13th Amendment prohibited slavery. For the first time, the Constitution specifically stated that slavery was prohibited. The idea being, we're going to remove the problem of slavery by doing away with the concept. We're going to prohibit the concept of slavery. Slavery will never again be written into the law the way that it was prior to the Civil War. And the 14th Amendment, we just said, they guaranteed equal protection of the laws. This was the idea that the law is going to apply equally to everyone no matter what race you are. You're going to be guaranteed the same protections under the law. And the 15th Amendment, which guaranteed the right to vote, attempted to protect those political freedoms that were granted in the 13th and 14th Amendment by allowing people to vote so that your vote now counts. And you can protect your political freedoms not by going to war, but instead by voting for people that are going to protect your interest. And finally, not an amendment, but the first Civil Rights Act in the United States, the Civil Rights Act of 1866. Yes, we had a Civil Rights Act almost 100 years before the Civil Rights Act of 1964. And what the Civil Rights Act of 1866 did was attempt to protect social freedom, meaning it attempted to allow for non-discrimination in the making of contracts, with the idea that's going to protect against discrimination in housing, because I cannot discriminate on the basis of race in deciding who I sell my house to or who I rent my house to. It's going to protect restaurants, so the ability to go to whatever restaurant you want, because they can't stop you from coming in based on race. So the Civil Rights Act of 1866 was an attempt to protect social freedom. And in fact, several of the provisions in the Civil Rights Act of 1866 are still relevant today, and we'll talk about those when we get to race discrimination. So here we've attempted to protect political freedom, we've attempted to protect social freedom. However, few provisions were made to protect economic freedom. There was no guarantee of entry into the domestic national economy. There was no way for people to be guaranteed the right to participate in the economy. And what we learned in the 100 years before the Civil Rights Act of 1964 was that if we don't protect economic freedom, then the other freedoms go away. Unless people are allowed to participate in the economy of the country, then it doesn't matter that we're going to give them right to vote, or it doesn't matter that we give them rights that say that they can use whatever restaurant they want or buy whatever house they want, because we have to empower these people economically. And that was the thing that Congress missed in their attempt to restructure the United States. There was no provision made to protect entry into the economic system. And so when I say that Title VII has its roots in this era, what I'm saying is that that was what Title VII was about providing individuals with the opportunity to participate in the economic fabric of the country.